A lot of this case legally has to do with stand your ground. You've heard a lot about it, and I was just curious, prior to this night, this incident, had you even heard stand your ground? No, sir. You'd never heard about it before? Wow.
That video was shown yesterday in the trial of George Zimmerman. Then today, the man who taught George Zimmerman about the Stand Your Ground law testified.
I wanted to teach the class from a practical standpoint where these students can really relate and take something from it and apply it to their own lives. You know, with Florida and other states, they have what's called the Stand Your Ground law, which evolved from the Castle Doctrine through case law.
And did you cover that specifically?
Yes.
Did you discuss specifically self-defense and stand your ground laws in the connection of violent crimes such as murder?
Yes.
That was Alexis Carter, who taught a course in criminal litigation at Seminole State College, where one of his students was George Zimmerman.
And actually, do you remember what kind of grade you gave him?
I gave him an A. You always kind of remember your smartest student, or the one that stood out the most, the one that probably wasn't the best student, and he was probably one of the better students in the class.
Joining me now, Faith Jenkins, a former criminal prosecutor, and Gary Casimir, a former New York City prosecutor who handles criminal and civil litigation now. Faith, the jury now knows what George Zimmerman looks like when he's not telling the truth. That Sean Hannity tape is his response clearly is not the truth, as the guy who taught him about self-defense and stand your ground law proved today.
Right, and that interview is going to be so crucial. The prosecutors are going to play that portion in their closing statements, because it's not just what he said, that the fact that he lied, it's how he said it. He looked right at Sean Hannity, he looked at him right in the eye, with his attorney sitting next to him, the entire nation watching, and his demeanor is the same as it is when he's giving these statements, telling his recounting of events of the night that he shot and killed Trayvon Martin. He does not flinch for a second when he looks him in the eye, and he obviously did not tell the truth. He said he never heard of Stand Your Ground, and then his professor testified that he went over this law numerous times in his class because he wanted his students to understand the practical impacts of this law. It was a clear and bold lie.
And it's obviously something that George Zimmerman understood, since he got an A in the class. Gary, Sean Hannity says wow after George Zimmerman says no, because it is a surprising answer and an important answer to a good question by Sean Hannity. And also, in saying wow, it kind of gives a person you're talking to a chance to amend what they're saying.
Sure.
I mean, you know, he could have said, well, I mean, I knew a little bit about it, or we talked about it in class once, but I'm not an expert on it.
Right. I think what you're going to have here is Wes, or the defense team, trying to explain that a self-defense course, maybe they didn't use the stand the ground in terminology. It is part of the self-defense law. It is an affirmative defense. And maybe what they will try to do is say that the way it's being described, it wasn't taught to him that way. Regardless of that, though, the question becomes, what do the facts present themselves? The mens rea involved here, you know, if you want to talk a little bit about what's the effect of knowing the stand your ground law? Does it change the circumstances or the facts that happened? And I don't think it will. The defense is going to say that didn't change the facts of what happened today.
Well, no, so that means he didn't have to lie about it, but he chose to anyway. So it's like, if he's going to lie about the small things just because he thinks he can get away with it, he's going to lie about the big things.
Yeah, I think the prosecution is going to try to present that, but I think the jury is going to be ending up deciding what happened that night. And you saw a lot of things here. You saw a guy going to school to try to be a better, quote-unquote, wannabe cop. That's a rarity. And so you have that element here. The prosecution is bringing this guy out. I was trying to suggest, oh, he's a bad guy because he's taking classes. I don't know if that's going to sell to the jury.
Well, no, he's an overzealous neighborhood watch guy because he's taking these classes and he wants to be a cop. He failed, but he is still trying to pursue that endeavor through neighborhood watch. He wasn't watching and listening as they instructed neighborhood watch to do. He was driving and carrying a loaded gun as well.
I guess the question becomes, does that make you a bad person? Does that make you, you know, you want to be a cop or you want to be a person, you're watching people? people? Is that going to suggest, is that going to change the jury's mind? Or did he do it on his own, or did he go to class? Did he get A's? Did he try to put out, I don't think they're going to reject him or reject the idea or make him into a bad person because he went to school.
This testimony brought in an opportunity for a kind of larger discussion of self-defense law, since there was an expert in effect on it on the stand. And so I want to show what Prosecutor Richard Mantee brought out about what they call imperfect self-defense, where you use, in effect, too much self-defense, too much power in your self-defense. Let's listen to how this exchange went.
What I'm talking about when it comes to imperfect self-defense is a situation where you do not meet the force that you are encountering. You meet that force disproportionately. It's excessive force.
So I guess then the ultimate level of force in these scenarios is deadly.
It's deadly force.
Like a gunshot.
Like a gunshot.
Faith Jenkins, that seems to be what this case is all about. Once that encounter was underway between Trayvon Martin and George Zimmerman, what was the proper amount of force to use?
Right, and George Zimmerman is arguing deadly force was necessary. And the prosecutors are countering that argument with, based on everything we know about George Zimmerman, his attitude towards Trayvon before he ever knew him, before he ever saw him, the fact that he called him a punk, he called him an a-hole, he thought he was a suspect, he was inclined to overreact. He was inclined to be the initial aggressor in this situation. And he had his gun, and it was loaded and ready to be fired.
Yeah, I think it's two different things, though. When you're going in this direction as a prosecutor, you have to be very careful. You can't say on one side he's a depraved indifference murderer, second degree, and then say he was in a fight and he overreacted. Those are two very different allegations, and they result in very different sentences. So if the prosecution is changing course, it's a sign they may be losing this case. That's not a great move.
Faith, if the jury were to go for a lesser charge in terms of a conviction, do you think it is a? I mean, Gary seems to be saying there could be a very high risk in the prosecution overcharging at this stage of the case.
I don't think the prosecutors overcharged here with second-degree murder based on the statements that George Zimmerman said about Trayvon and assuming that he was committing a crime when he was just walking down the street and referring to him as if he was a part of a group. These people multiple times, putting him in a category with other people that he saw in the neighborhood that he thought was suspicious, and they always got away, so Trayvon was not going to get away. Now, in hindsight, after Trayvon Martin is killed, of course, everyone learns that he was not doing anything wrong. That's why they charged him with second-degree murder, and that's understandable. It is a high threshold. I think there's a possibility they're going to ask for a manslaughter charge, and there could be a compromised verdict. That's what happens in a lot of these cases.
Well, Faith, I tell you right now, if they charged him simply because he used F-punk or he was a watchman who thought certain people committed crimes or looked a certain way, it's not enough. They got to do a lot more than that.
It's a depraved mind. It's a mindset. That's what they're arguing here.
Not enough. Not enough.
Faith Jenkins and Gary Casimir, thanks for joining us again tonight.
Thank you.
Thank you.
Coming up next, the forensics in the case so far, including the DNA evidence on the gun.